So how's the weather across the pond, Ben?
It's beautiful.
Great.
Early as was today.
All right. Hey, Jim, is this you? Jim Langdon?
Yeah, I'm on, Tom.
Okay, great. Why don't you and Ben flip for who goes first? We're live here with the press.
Ben, you go.
Okay. Good afternoon, everyone. As you just heard, Jim Langdon from Dorsey Whitney is on with me as well. And we wanted to spend some time telling you that, as promised, we are filing our notice of appeal today with the Minnesota Supreme Court. The court will now set a briefing schedule, and we will file our full brief according to what the court orders. We do believe that the district court got it wrong on the law, and wrong because the Minnesota tradition and law are to enfranchise people, and their decision disenfranchises many Minnesotans whose votes have been wrongly rejected. We can go into greater detail with you on the reasons, but they're the same ones that we talked about often during the trial, that different rules were used by different jurisdictions that created an equal protection violation that the court just really didn't care about. The court changed the rules of the game on Friday the 13th by coming up with a set of rules that were different from what Minnesota jurisdictions used on Election Day. And basically the court took on a strict compliance scheme of Minnesota law when in fact the counties and cities had generally used a substantial compliance standard. The court's Friday the 13th ruling also means that there are literally thousands of illegal votes in the count that they certified as the final tallies for the candidates by their own definition. The court excluded evidence on these variations and different practices in the counties that we think was an evidentiary error on their part. We think they were wrong in not ordering inspections on the double counting, and they were wrong on their conclusions of law on the missing ballots in Minneapolis 3-1. So, Jim, any details you would like to add to that?
No, I think you've covered it, and we can respond to specific questions. Most of the details will come out when the brief is filed in any event, which will be as soon as the court tells us to file it.
Yes, the notice is, if you have it already, is a fairly perfunctory document of about 5 pages, and the brief will obviously go into much more detail on the facts and the law.
All right, great. Thanks, Ben and Jim. And with that, we'll take your questions. If you have a question at this time, please press #8, and I will answer them in the order I receive them. Just so you guys are aware, there's a brief pause between when I unmute you and when you can ask your question. When you are told you have been unmuted, feel free to announce yourself and ask your question. Our first caller today is the Associated Press in Minneapolis.
Yeah, hi. This is Steve Karnowski from AP. So what makes you think that you'll prevail at the Minnesota Supreme Court when you didn't prevail before the contest court?
Well, appellate courts generally have a broader view of the law, and this court expressed its reluctance to get involved in the constitutional issues. And in fact, they believed that their charge was only to look at the wrongly rejected absentee ballots, and the Supreme Court has said in other opinions that it has issued that it takes a much broader view of the law. I mean, there are lower court opinions that are reversed from time to time in all manners of the law, including recounts. So that's what Supreme Courts are for.
That's right, Ben, and we think that the contest court may have felt constrained by some of the older Supreme Court cases, 1975, 1937, some other cases, and as a lower court wasn't about to say that the Supreme Court cases didn't apply here. However, the Supreme Court itself can make it clear that those cases involve very distinct circumstances that aren't applicable here. And as a result, they don't govern this action, and the constitutional issues of equal protection and due process do.
All right, thanks, Steve. Our next question comes from Minnesota News Network. Go ahead, Bill.
Hi, it's Bill Werner with M&N. Couple-part question for Mr. Ginsberg. How soon do you think that you're going to get oral arguments on this? Do you have any idea? And the second part of my question is, if you don't, and I'll ask it again, and I know that's been asked a million times, but if you don't prevail at the Minnesota Supreme Court, do you go a federal court route?
Well, we're just thinking about the Minnesota Supreme Court, for now. And I don't have any particular sense on when the court will schedule oral argument, but they are supposed to take it on an expedited basis. Jim, any particular insights?
Yeah, that's right, Ben. The statute tells them essentially to set aside all other business in favor of dealing with this. And we have perhaps a little bit of guidance from what the court did in December when issues were brought to it. It put together, as you'll remember, very time-sensitive and expedited schedules. We would expect to see oral argument, anywhere from 2 weeks to 2 months from now.
I'm sorry, sir, I didn't get your name. Would you mind identifying yourself?
Yes, it's Jim Langdon.
Thank you.
All right, thanks, Bill. Our next question comes from Scott Wente from Fargo Forum. Go ahead, Scott.
Yeah, hi, thanks. Just to clarify, are you certain that the court will actually have to schedule oral arguments, or could they do this without an oral argument? And then, lastly, Mr. Langdon, you said that you expected it could take anywhere, I think, up to 2 months, did you say?
I did. I think you're correct. They do not, under the rules, have to schedule oral argument. We do wish to have oral argument and would expect it to be scheduled. And again, it's completely within the court's discretion as to when they set the oral argument. I'm sure that they're very sensitive to the passage of time in this matter, and will do it as soon as they believe that it's reasonable in the circumstances. And as I said, that could be almost any time, and my pick was somewhere between 2 weeks and 2 months.
And then just quickly,
the usual course of action that I think they will follow is to tell us when they want to get a brief from us, and to give the other side an opportunity to file a brief, and then give themselves some amount of time to study the briefs and figure out where they want to go in the oral argument, and then schedule it.
And that's right. In the normal circumstances, with a typical civil case, the process could take anywhere from 3 to 8 months. So this is, whatever they choose will be very expedited.
And just to follow up, can you talk briefly about the scope of the appeal? Are you including the issues of double counting and the Minneapolis ballots in the appeal?
Yes, they will be included as well, and they're mentioned in the notice of appeal.
Thanks.
All right, great. Next question, I believe, comes from Emily from CQ.
Hi, this is Emily today at CQ. I just had a timing question, I think most of which has been addressed. But does the court have any limits on the span of time that it has to give you before asking for your brief, or is that entirely under the court's discretion as well?
It's entirely up to the court's discretion.
Okay.
All right, thanks, Emily. Next caller, I believe, is Jason Hoppin from the St. Paul Pioneer Press. Go ahead, Jason.
Hi, Jason Hoppin at the Pioneer Press. Even if you get the court to open up additional ballots, what makes you think they'll break your way when they haven't in the previous 2 rounds when they've opened absentees?
You guys like asking this question, don't you, Jason? Look, as we've said before, the ballots that were opened up in the canvassing board recount, and really by this court came much more from precincts that were carried by Franken than by Senator Coleman. And in the ballots that are left, they tend to be from precincts that were carried by Mr. Coleman, by Senator Coleman. But I mean, as we've also said all along, you just never know what any one ballot will hold. But as Senator Coleman has also emphasized in this process, the principle at stake is that Minnesota is a state that believes in enfranchising, not disenfranchising voters. And where one person's ballot has counted and an identical ballot has not been counted because different jurisdictions treated it differently, there is a principle at play here. So a large measure of the reason for this appeal is that principle.
Thanks.
All right, thanks. I believe our next question comes from Jay Weiner. Go ahead, Jay.
Here I am. Hi, Ben. Just out of curiosity, where are you right now?
I am. My mind is in the state of Minnesota, even if my body is not, and I am not in any place where you have a relative.
Fine, but you're in Europe, are you right now, or not?
I'm talking to you on the phone, fella.
Oh, okay, all right. So you're in an undisclosed location.
A secret and undisclosed location.
Okay, that was my only question. Thank you.
Showing one last question. Hi, go ahead.
Hey there, Chris Stern with Bloomberg. I'm sorry, didn't quite get it. Did you have to lay out any reasoning in your notice of appeal? And if you could you just give us a couple quick hits on what it is that you guys are going to be specifically looking at?
Well, Jim, can you describe the requirements of Minnesota law for a notice of appeal?
Sure. The notice of appeal is accompanied by a second document, which is called statement of the case, and that's prescribed by statute or by rule rather, has to contain a variety of information, including the name of the court and the case and the judges involved and by what jurisdictional statute you have the right to appeal and the like. It also includes a list of the issues that the party intends to appeal regarding. And so you'll want to look at that document, but that lists the issues, and it includes the issues.
Sorry, the host has opted to drop you from the call. Thanks for calling. Goodbye.